Judge, she's not.
Well, okay, but
Okay, I'm sorry.
I'm asking whether or not the people are aware that she's still staying there. The information defense has is that she's not there.
Yeah, she never lived there, Judge. She would stay there for several days or something to that. But other than
I get that, Mr. Killowalt, but I don't know what people's living arrangements are. I have his address in the file as the address that this occurred at. You're telling me she's not there. I was asking for verification from the people as to whether or not that's the case. That's what I need.
when you come to the podium, would you state your name?
Thank you. All right, what are we doing?
They have several preliminary examination. At this time, we were unable to proceed as to count one, but ask for count two to be removed to district.
On behalf of my client, Judge, I would ask that count one be dismissed.
All right,
Court's going to remand it to district court. I'd like to make a bond argument.
certainly. Count one is dismissed. I'll continue to defendant's not guilty plea as to count two. Pretrial will be set
July 13th at 9 a.m.
July 13th, 2026, 9 a.m. before Judge Washington. Yes, that's the bond.
Judge, I know you've heard this argument before, but again, my client is the father of 4 minors. Currently, his older daughter, 18-year-old, has been holding down the family. They all live in one apartment. The rent is overdue. My client is gainfully employed, grass cutting business. The victim in this matter is not the biological mom of any of the kids. There's no need to he be there. My client does not want her there. What we're asking the court is to release my client on a reasonable bond, Judge, hopefully PR, but if necessary, tether.
He responds.
Your Honor, at this point, I would object. If the court was going to be changing, I would ask that you change to the $5,000 cash rate, given the severity of the assault of this case. I would have concerns for the victim's safety. Present at the house.
But, okay. But she's not here, correct?
Correct.
And as I'm looking at the addresses, the International Drive is his address.
Yes.
Correct, Your Honor. I believe she's been staying there for a short period of time.
Do we know whether or not she's staying there now? No.
Just be careful. Judge, she's not.
Well, okay, but
Okay, I'm sorry.
I'm asking whether or not the people are aware that she's still staying there. The information defense has is that she's not there.
Yeah, she never lived there, Judge. She would stay there for several days or something to that. But other than
I get that, Mr. Killowalt, but I don't know what people's living arrangements are. I have his address in the file as the address that this occurred at. You're telling me she's not there. I was asking for verification from the people as to whether or not that's the case. That's what I need.
Judge, for what it's worth, she has her own separate address. And that's stated in
Okay, so I was ready to roll. Do you want to keep talking? What I'm going to do is I am going to reduce the defendant's bond given the circumstance. I'm going to reduce his bond to a $25,000 personal recognizance bond. I will indicate that defendant prior to release is to be placed on a GPS location tracking device with the exclusion zone to be provided by the prosecutor's office for the alleged victim's address. Right. Thank you.
Thank you, Your Honor. That she was a text. Oh, okay. Call me when you get out.
So court does call the case People versus Christopher Johnson.
And then on behalf of the people, Your Honor. I mean, silly.
Mr. Who? Who's on the in custody? I don't know what to tell her.
Mr. Bernard. And Mr. White.
Oh, okay, let's do that one then. Court does call the case, people versus Rashid Abdullah.
Assistant Public Defender Ben Denowith on behalf of Mr. Abdullah, who is approaching the podium now. Sir, would you please state your name for the record?
Rashid Abdullah.
Your Honor, today's the date and time set for exam. The defense is going to waive.
All right.
And my client has signed the form. I'm providing it to the bailiff now.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count. Sudeno.
Your Honor, we will stay in mute and waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 16th at 1:30 with Judge Slay.
July 16, 2026, 1:30, Judge Slay. Bond will continue.
Thank you, Your Honor.
Thank you. Court recall. Wait. Oh, I'm busy here.
Oh, my apologies. My apologies.
Okay, it's all right.
Got to go ahead, Ron.
Court calls the case, People versus Christopher Johnson.
This is on behalf of the people, Your Honor.
Sorry about that, Your Honor. Good morning, Ivan, 65879, appearing on behalf of Mr. Christopher Johnson.
Your name, sir?
Christopher Johnson.
Thank you.
As a preliminary examination at this time.
And we have no objection, Your Honor, to that request for
Are you moving to dismiss?
we are moving to dismiss without prejudice in this matter, Your Honor.
People being unable to proceed, this case is dismissed as without prejudice on the defendant's motion. Thank you.
Thank you so much, Your Honor. You and your staff, take care.
Thank you.
Were you going to take him down? Yes, you were. Okay. You know, I almost didn't say anything because I wanted to see it happen. I don't know. You need to understand, Alan's a little touchy about that. Court calls the case, People versus David Yardley.
Morning, Your Honor. Raymond Cook for the people.
Morning, I'm Rob J. Gill on behalf of Mr. Yardley, who is a little bit still changed to it.
David Yard. Thank you.
Your Honor, this is a date and time set for the preliminary examination. At this time, the people are unable to proceed.
Judge, we'd ask this matter be dismissed.
People being unable to proceed, this case is dismissed on defendant's motion without prejudice. All right. Thank you.
So it's really have at the moment for you.
Really? That's it? What's Gaddy have?
Exactly where you at.
Oh, ready? Well, I did not ask that. Oh, that was cute. On Zimmerman. That's a hold. Okay, who's on the other side of that? All right, how many witnesses are we looking?
At minimum 3, depending on their testimony, it could be as many as 6.
Oh, joy. All right. Do I have any other short matters or? Okay, good answer.
So this game is on 2. Don't know. Yes, Scotty is on it. Which my understanding of those beautiful. attempt to plead on that. You'll get a paperwork again.
Okay.
Still waiting on two.
We're waiting on two attorneys.
Yeah. Just kidding.
What?
It's part of all is well, and I didn't see it. If they're, I don't know what's happening.
I thought I saw Mr. Muller.
Yeah, there are parents here.
Okay. And Ms. Barnwell's out in the hall. That might be a good thing for a while. Saying, oh, wow, Alan, that's rude. What? It's hard being me. And what? Oh, Zenda's leaving? Goodbye, Miss Zenda. Yeah. So Gaines is walking. That's okay, Miss Tanner. You don't have to say goodbye. Goodbye. Oh, okay, okay. No, my bad. Guess I spoke too soon. What's Gaines doing? So how many more do I have left?
2, 3, 4, 5 is outside the whole, so 6. Oh,
So 5. Okay. Are any of those going to be short? Because once I start that one, there's not going to be anything yet. Good morning.
Your Honor, I know I should have done this before. I believe Ms. Dover and I will have a resolution, and I would request if the court would permit a no contest plea. I do need just a couple minutes to print out the police report, or I could email it.
Okay. If it's probably to email it to Ann. Is that a correct statement, Ms. Dover? It's going to be a no contest. Okay. I'll do that. I'll take a break to go through the report, but if you can get the report to Ann as soon as possible.
Okay.
And then who?
Your Honor, I also have a quick one with Ms. Barnwell. I think it's not going to go.
Okay. Does she know that? Yes. Why don't we do that? Today. Check. Please. Third. It is the 23rd.
you are too, Jim.
Okay.
Is on another hearing in the hallway. She said,
Oh, so she told me to wait. Okay. Ms. Gaines, good morning. Are we ready on any of yours?
Yep, she just needs me to waiver.
A waiver.
Okay.
They're out.
Yes.
This court does call the case, People versus Christopher McDade.
And over for the people, Your Honor?
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. McCade, who is approaching the podium.
Your name, sir?
Christopher McDade.
You are waiving your right to a preliminary examination?
Yes, Your Honor.
I understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Correct.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Correct.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following.
Your Honor, just to also put on the record our agreement was that Mr. McDade does have a circuit court matter already And so he is waiving this case with the offer of admitting to count 2 and count 1 being dismissed in the circuit court, keeping all his cases together.
Got it. That's right. All right. As to the arraignment, you waive formal reading, your client stands muted.
That is correct, Your Honor. We acknowledge and waive reading at this time.
And waive formal reading, standing mute as to both counts. Court will enter not guilty plea. Pretrial will be set
August 25th at 1:30 with Judge Conkey.
August 25th, 2026, 1:30.
Yeah. Thanks, Your Honor.
Bond will continue. Thank you. I think it's filling out that form. Ms. Dover's got to sign off on that. For me.
All set, sir.
Okay, thanks, Judge.
She wasn't filling out anything. Oh, well, it's okay.
Oh, I already turned in the waiver for it.
Skip.
Yes.
No, she didn't. Okay, I saw it. I know. I saw. Why you got to point it out like that? Like I missed it or something. Why are you doing that to me, man? That's what I'm talking about. Okay, so we have Miss Yagi's that one. Who else? And then Barnwell will be on her way in. That's 3 out of the 5. Right? So I have 2 more left. What was Mr. Mullen's intention?
He believes they're going to come to a resolution. His parties are still working.
Okay. And who's on the other side of that? Okay.
Yeah.
Okay. And then we have one more.
Mr. Cook in these games.
That one I think we're trying to resolve, but no promises.
Okay. All right. I always like the way Cook puts it. Okay, so with all of that going on, then you sent the police report. Oh,
My Wi-Fi was out, so I'm using that phone.
okay. So once that gets to you, I can review that.
If you can, that would be wonderful. Thank you.
Then I can resolve that. We have that one. Barnwell will be ready hopefully soon. And I can take care of that once I can take care of 3, well, including an exam, but okay. That's all I can do. Good morning. I'm sorry. On Barnwell? She's in a hearing, another hearing, probably via Zoom. But Ms. Dover, I think, thought that wasn't going to go. So we may be able to get rid of that. Did he need something from us? No. Well, guess I'll settle. What did you say? Do I need a break? Think I should take one?
No.
Okay, then I'll sit here. Doing absolutely.
May Mr. Getty and I approach very briefly?
Should have gotten out.
Bring up my cord, Your Honor.
Oh, okay. All right. I just saw you pulling wires out of the table. I was worried. All right. I have before me a plea form. Form indicates that defendant is going to plead no contest to as charged as account of indecent exposure. On her successful plea to that charge, then there's an agreement, a sentence agreement to a prosecutor's deferred. That's the court's sworn.
That's correct, Your Honor.
That is correct, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear in affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Okay.
Do you state your name?
Sharon Abbott.
Okay. I just didn't hear it. Ma'am, it is this court's understanding that you're going to plead no contest to charge of indecent exposure. That's a misdemeanor, punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
I do.
Do you understand what a no contest plea is?
I do.
All right, two things about it. I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge.
Correct.
Understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Lack of recollection.
And ma'am, to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
Signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
Yes.
All right. And also because, well, I want to ask you that. Court has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 25-14872. Any objections to the court having reviewed that report?
None from the people.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I do have to apprise you, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
None, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea. Oops. In this case, defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
April 29th at 12 noon.
April 29th, 2026, 12 noon. And we'll continue. All right. Thank you.
Thank you, Your Honor.
What? Court calls case, People versus Kent Robbins.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Robinson. The Office of the Public Defender does not believe a conflict exists between this honorable court and the Office of the Public Defender. But if one were to arise, we would waive any claims that a conflict exists.
Your Honor, the people similarly do not believe that any such conflict exists, and people make a waiver of any potential conflicts in the avoidance of all doubt.
Right. The court, for its part, also does not believe there's conflict either under the Michigan court rules or the cases decided thereunder, to the extent a conflict does exist, given the witness or will consent to. Your name, sir?
Robinson.
All right. I have before me a plea form that indicates that he's going to be pleading guilty as charged to the domestic violence. Is that correct?
Yes, sir.
That's our opinion.
May I have it?
And you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name, please.
Ken Robinson.
Sir, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that? Still wish to plead guilty?
Yes.
To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form previously?
Yeah.
Is that correct? Any question regarding any of those rights?
No.
Look at paragraph 5. You see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Probation.
Probation. Were you on probation at the time of this offense? Yes.
Yes.
Okay. I do have to advise you then that your entry of a plea in this case could be a violation of that probation. If it is considered a violation of that probation, you could be sentenced to the maximum allowable under that other charge by that other court. You understand that? Understanding that you still wish to plead guilty to this charge.
Yes.
Has anybody promised you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're indeed guilty of this offense?
Yes.
On the date of January 14, 2026, at the location of, what is that location? 3000 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. What did you do regarding a Sharonda Stewart Moss that makes you think that you're guilty?
I hit her.
You hit her?
Yes.
All right. You did that on purpose?
Yes.
All right. You didn't have her permission to do that, did you?
Yeah.
You didn't have her permission to do that?
No.
All right. And who was she to you?
Girlfriend. Girlfriend.
Girlfriend? All right. Sir, if I accept your plea, I do have to advise you to commit misconduct between the time of my acceptance of your plea and the time of sentencing. That you would not, you commit misconduct as defined under the Michigan court rules. You would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
April 20th.
April 20th, 2026, 1 p.m.
Yes.
1 p.m. Its conditions will.
Your Honor,
Yes.
would you consider allowing him to use the phone at the jail, making outgoing calls?
Any response from the people? Like I've revoked it previously, and
Looking at Mrs. Enda's notes, it looks like there were numerous phone calls that led to his phone privileges being revoked. I would ask that bond conditions remain the same, or at least give APs Enda time to respond to that change bond.
Right. I think I'm going to do that. I'm going to deny that request at this point.
Yes, Your Honor.
All right. Court calls case People versus Austin Shepherd.
Morning, Your Honor. Raymond Cook for the people.
Sherilyn Foster Tucker on behalf of Austin Shepherd.
Austin. Your name? Austin Shepherd. Yeah.
Your Honor, this is the date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed this case dismissed. That's on defendant's motion without prejudice.
Thank you, Your Honor.
Thank you.
Thank you. Have a good one.
You do the same. Court calls case of the People versus Taisha Wynn.
Morning, Your Honor. Raymond Cook.
Sherilyn Foster Tucker on behalf of Tiaja Wynn.
Tiaja Wynn.
Thank you.
Your Honor, this is the date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed on motion without prejudice.
Thank you, Your Honor.
Court calls case of the People versus Rashad Ahmad.
Morning, Your Honor. Raymond Cook for the people.
Morning, Your Honor. Sam Bernstein, standing in for the attorney of record, Charlotte Steffen, with and on behalf of Rashad Ahmad.
Good morning, Your Honor. That's with your permission, sir.
Yes, sir.
All right.
Your Honor, this time the people are unable to proceed.
Your Honor, we move to dismiss.
People being unable to proceed, this case is dismissed on defendant's motion. That's without.
Thank you, Your Honor.
Thank you.
Have a good day.
Go on.
Court calls the case of the People versus Israel. Diego Guerra.
Morning, Your Honor. Raymond Cook for the people.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Diego Guerra, who is approaching. And for the record, Mr. Diego Guerra, if you could
So I'm going to ask you to pull the mask down, but to state your name for the record, please.
Israel Diego Guerra.
Thank you.
Your Honor, this time the people are unable to proceed.
Defense would move the court to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice on defendant's motion.
Thank you, Judge.
Court calls the case People versus Jacob Grammatico.
Your Honor, reading for the people.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Grammatico, who is approaching. And Mr. Grammatico, once you're here, if you could state your name for the record, please.
Jacob Grammatico.
Thank you.
Your Honor, this time the people are unable to.
Defense would move the court to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's on defendant's motion without prejudice.
Thank you, Judge.
Thank you, Your Honor.
Is that it for you?
That is, Judge.
Oh. No,
Your Honor.
continue, sir. Court calls the case People versus Caleb Kasham.
Your Honor, reading for the people.
David I. Goldstein appearing on behalf of the defendant. Your Honor, I spoke to Mr. Kasham this morning. He put Monday's date in his calendar, but he didn't put today's date in his calendar. He's on a job site and cannot get here this morning. And as my knowledge, this is the first time he has failed to appear. So I'm asking if we consider an adjournment in this matter.
Your Honor, the people were able to proceed this morning. The victim did appear. We have since excused him once we learned the defendant would not be here. I would leave it to the court's discretion. Bench warrant or adjourn.
Let me add one additional thing, Your Honor. An offer was made today for the first time in this case, which obviously we would have had to discuss.
Is he going to take that offer? I mean, I'm not carrying this over because he forgot to put it in. I gave 2 dates and everybody else remembered them.
All I can do is represent what I know to be true, Your Honor. As far as taking the offer is concerned, he doesn't even know the offer because I haven't discussed it with him yet.
Well, I'll be here pretty much the rest of the day. I don't know how long Mr. Cook's going to be here. If he can get here, he can get here, but I'm not.
Well, I already said that to him when I spoke to him, and he said he's on a job site and can't get here.
Bench warrant will issue for defendant failure to appear. Bond will be set amount of $10,000 cash as surety. I won't issue the warrant until Monday, 13th.
Thank you, Your Honor.
Court calls the case People versus Kareem Omar.
Your Honor, Raymond Cook for the people.
Your Honor, Joe Simon on behalf of Mr. Omar. State your name, please. Kareem Omar.
Okay. This is the date and time set with Mouse Settlement Conference, and people are able to proceed. It was an offer extended to the plead under 7694A. My understanding that all that has been declined. This is Ms. Senda's case. I can't represent that all. Continue past.
Waiver.
That's what I was about to say.
All right. Sir, you signed this waiver of trial by jury?
I do, yes.
Pardon?
Yes, Your Honor.
You did? Okay. And you understand that you have a constitutional right to have this matter tried before a jury?
Yep.
And by signing this form, you're waiving that right?
Your Honor, yep.
All right. People also waive their right?
Yes, Your Honor.
Based upon the statement of counsel and defendant, court will consent to have the matter tried before without a jury. Non-jury trial in this matter will be set for
April 29th.
Oh, I thought this was the 27th.
Oh, I'm sorry. April 27th.
Thank you.
April 27th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Bob, we'll continue.
Thank you.
Court calls case People versus Ontario Robinson.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Sam Bernstein with him on behalf of Mr. Robinson. Mr. Robinson, can you please state your name for the court?
Ontario Robinson.
Being time set for final settlement. Well, it may be also considered sort of an adjourned motion hearing. This is the case where the law firm partner, necessary witness, said it's blatant unavailable. I have not been able to maintain contact with him since the last time over a month ago that we were able to establish contact. I don't know if he's going to be available in the near future. This has already been adjourned at least once on the people's request. I don't believe I can in good faith ask for another adjournment. I would just represent that when that trooper does become available, you would likely reauthorize the case if it were to be dismissed.
All right. I understand that, Your Honor. It's just been like 5 months, so we would still move to dismiss.
At this time, because of those reasons, people are unable to proceed. You're moving to dismiss.
Yes, Your Honor.
All right. Case is dismissed. That's without prejudice. You understand that, sir?
Sir.
Okay. And this case could be brought back. Thank you.
Thank you and have a great day.
Same. Court calls the case of the people versus Christopher Seelig.
People?
Your Honor, considered on behalf of Christopher Seelig, who is making his way to the podium now.
Your name, sir?
Christopher Seelig.
Unable to proceed.
Your Honor, I would make a motion to dismiss on behalf of defendant.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you very much, Your Honor.
Court calls the case of people versus Aaron Bucko.
Conrad Siller on behalf of Pittsfield Township.
Ron Brown appearing on behalf of Mr. Bucko, Your Honor.
Aaron Bucko.
All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
All right, the defendant in this case is going to be pleading guilty to the charge of operating while visibly impaired, and that's the added count 2. Upon a successful plea to that charge, count 1 would then be dismissed. That's the court's full understanding of the agreement.
That's correct.
Yes, Your Honor.
All right, may I have him sworn?
You solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yeah. State your name, please. Aaron Bucko.
Sir, it is this court's understanding that you're going to be pleading charge of operating while in. That is a misdemeanor, punishable by up to 90 days in jail, up to a $300 fine plus court costs. Court to order any rehabilitative services or community service the court deems necessary. Could order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency government. Understand?
Yes, sir.
Understanding that, you still wish to plead guilty?
Yes, sir.
To that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
Signed an advice of rights form, is that correct?
Yep.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights that are contained on that form.
Yep.
Yes. You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
Sure.
You're doing this voluntarily and of your own free will? And also because you believe that you're guilty of this offense? September 7th, 2025, the location of Glencoe Hills Drive, Pittsfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Yes, sir.
All right. Prior to operating that motor vehicle, did you consume intoxicating liquor? What'd you have and how much?
That I'm not exactly sure.
0.223 were.
Yeah.
Were you stopped by the police or was there an accident?
He's passed out behind the wheel, but
Yeah.
the engine running, so he was operating technically.
So is that correct, sir?
Yes, sir.
All right. And the police did arrive
Yes, sir.
and you were arrested. You were taken to the hospital for a blood draw.
Yes, sir.
And the blood draw netted results that your counsel just indicated. All right. You don't have any reason to dispute those blood test results, do you?
No, sir.
Take everything into consideration on that date and at that time. Do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, sir.
All right. Counsel, I do have to advise you, sir, between the time I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rule, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation recommendation. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant's referred to Von Schwartz for alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
April 29th at 12 noon.
April 29th, 2026, 12 noon.
Bond continue.
Bond will continue, sir. Stop down at my probation department before you leave the building and get it started.
And make sure you give them this so they know you.
Court calls case people versus Frank Hearns.
Conrad Siller on behalf of Pittsfield Township.
3 doors down.
Frank Hearn,
Frank Turner.
What are we doing?
Plead double park.
That's correct. Yeah, double parking. He has filed an appeal with the Secretary of State.
Mr. Hearn, do you admit responsibility to the fact that on July 26, 2025, Campus Parkway in Pittsfield Township, that you double parked the motor vehicle?
Yes.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. When can you get that paid?
Can you get 60 days?
Pay it by June 30th. 2020.
Thank you. Thank you.
Thank you.
You're welcome.
Court calls case People versus Mars and Morton.
All right, so on behalf of Pittsfield Township.
Ron Brown appearing on behalf of Mars and Morton. Gotta take it down.
Gotta take all that off.
Double parking. So we talk.
All right. Your name?
Marze Morton.
Okay. What are we doing?
I'm gonna move to add count 2 double parking, Your Honor. Accept the admission and restoration charge.
How long you need to pay?
Well, sir, do you admit responsibility to the fact that on about date of August 6, 2024, Packard Road, Pittsfield Township, that you double parked the motor vehicle?
Sir.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. When can you get that paid?
60 days.
Paid by June 30th, 2026.
Thank you. Thank you.
Court calls case People versus DeSure Bond Sanders.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Andrew.
Your name?
Israel Bond Sanders.
Your Honor, this time the people are unable to proceed.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you.
Yes. Court calls case People versus Robert Bowe.
Ron Brown appearing on behalf of Mr. Bowe.
Take care, Connor. Your name?
Robert Bowe.
Your Honor, this time the people are unable.
Move to dismiss, Your Honor.
Being unable to proceed, this case dismissed without prejudice. Thank you.
Thank you.
Court calls case People versus Juwan Campbell.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Campbell. May I check the hall?
Sure.
Watch the other. No answer, Your Honor. Can you pass?
No. Bench warrant will issue for defendant's failure to appear. Bond will be in the amount of $10,000 cash. Warrant will issue immediately. Court does call the case People versus Austin Ingram.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Ingram.
Your name, sir?
Austin Ingram.
Thank you.
Your Honor, people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without.
Take care.
Thank you. Court calls case People versus Alicia Callowith.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Calloway, Your Honor. May I approach with the prosecutor once she introduces herself?
We don't need to approach.
All right,
Introduce yourself.
Alicia Calloway.
thank you.
People are unable to proceed.
Move to dismiss, Your Honor.
For being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
Thank you.
You're free.
Court calls the case People versus Carlos Mack.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf. Your Honor, may we approach very, very briefly?
Very briefly.
Hold on.
Yes.
Sign right there for me.
I was told get him on.
Yeah.
Yeah, so I'm trying to.
Yeah, you're trying to get it, but
Yeah.
it's better than what you originally charged.
I was. Oh.
Here's your receipt showing. But you,
From I have it,
Yeah, no.
defendant will be pleading guilty to an added count 2 of no operative person, misdemeanor by up to 90 days in jail, $100 fine plus court costs upon his third count 1 would be dismissed. That's the court's full understanding.
That's correct, Your Honor.
yes, Your Honor.
May I have it sworn?
Right here. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
That's correct.
State your name, please.
Carlos Mack.
Sir, it is this court's understanding that you're going to plead guilty to the charge of no valid operator's license on person. That's a misdemeanor, punishable by up to 90 days in jail, $100 fine plus court costs. Do you understand that?
Sir.
So wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
That is correct, sir.
You signed an advice of rights form, is that correct?
One of these, you signed one of these before.
Yes, sir.
All right, any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
That's correct.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
I am.
Okay, were you on probation at this time?
I am right now.
Of this? Of this time?
Oh, no, sir. No, sir.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce?
No, sir.
Doing this voluntarily
That is correct.
and of your own free will,
That is correct.
and because you believe that you are indeed guilty?
That is correct.
On October 18, 2024, at the location of West Michigan Avenue near Clover Lane Drive, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
That is correct.
Were you pulled over by the police?
That is correct.
And did they ask you for a driver's license?
That is correct.
And were you unable to give them a valid license?
That is correct.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right. Court will accept the defendant's plea to count 2. Count 1 is dismissed. Anything either of you want to say before I impose sentence?
Nothing from the people.
He's made some recent payments. He's trying to get his license, Your Honor.
Sentence of the court, $250 fines and court costs. I'll suspend 90 days in jail. When do you think you can get that paid, sir?
The 250.
90 days?
Yeah, give me that. Can I get 90 days?
Jail?
No, not. No, sir. No.
I didn't know what.
no.
I didn't ask you.
No.
And I said, and then
No, sir.
asking me for 90 days.
No, sir.
90 days to
I
pay.
had no reaction until I said that. He's cool as a cucumber. I said that. Oh, no.
I got pickled on that one.
June 30th, 2026.
I have a quick question, Honor.
Yes, sir.
Because I was trying to pay for my reinstate my renewal like today or tomorrow for my license. I got to pay that fine on top of that before that.
We're trying to pay what?
For my license, my reinstatement renewal.
We're trying to pay the reinstatement.
The 125?
Yeah.
The 125. But the 125 would be paid at the Secretary of State.
Right. No, correct. That's what I'm saying. Because now I got this fine on top of that. So I have to pay the fine first.
Okay, so the way I think it works is you can pay that 125 at the Secretary of State, but then don't not pay this because you're going to you'll get a suspension will happen.
Right. What I was saying, because I made a payment yesterday, but I couldn't pay my reinstatement renewal because I had an older ticket that I had to pay on.
Was it this ticket?
Yeah.
I think
That's awesome. License for that. Oh, it's it's better than yeah.
Yeah. Sir, it seems to me that you got a suspension from a ticket from 2023. This court.
Is that 241-1404?
The ticket number, it looks like it's a suspension from an operating while intoxicated. Our ticket number is 231-0445.
Yeah, that's what I was paying.
Yeah, you pay.
And you have another one.
Yeah, that's a full case.
Well, that's off of the same one.
Yeah.
So it looks to me like there was a suspension, but you may have done something and they were suspended to April 2nd of 2026, which may be why you're able to potentially pay your reinstatement fee. You then have a ticket.
Oh, it's a big.
Out of 14B.
Here. You're on street. You on Whitaker.
Never mind, because your suspension was ended in 16. It might, well, that's older, so it might be this one.
That's the only one
They did it, but there's an adjudication at least on it. Okay.
Yeah.
So, I don't know what the Secretary of State will say. You can tell them you pled to a no ops.
Okay.
And see if they'll let you pay it.
All right.
Got time to pay this one.
Okay.
All right.
So,
all right.
All right.
Thank you. Court calls case People versus Nicholas Meath.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Nicholas Meath.
Nicholas Meath.
Move to dismiss the charges.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you. Thank you.
Court calls case People versus Robert Lee Redding.
Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Robert Lee Redding.
Your name, sir?
I'd also Robert Redding.
Your Honor, this time the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed.
Thank you.
Without prejudice.
Thank you.
Court calls case of the People versus Jeremy Rice.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Jeremy Wright.
Take name.
Jeremy Rice.
Your Honor, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is without prejudice.
Thank you.
Court calls case People versus Nabia Smith.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Smith, Your Honor.
Good morning, Nivea Smith.
Your Honor, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
Thank you.
All right, thank you. Court calls the case People versus Ryan Studeville.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Studeville. Can I check the hall?
I guess yes. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. Warrant will issue immediately. Court calls the case People versus Michael Taylor.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Taylor.
Good morning. Your name? Michael Taylor. Thank you.
Current people are unable to proceed.
Move to dismiss.
For being unable to proceed, this case is dismissed. That is without prejudice.
Thank you. Yeah.
Court calls the
Get
case.
his bond refunded now?
What, he wants his money back?
Just like this?
Yeah.
He can't have no money.
He wants his money back?
Yeah.
How much you pay?
I got bills.
Take your receipt and your ID to the county.
Okay.
They'll see that it's dismissed. They should be able to return your bond.
Do I need to present a receipt
If you got
when they look it up?
You have an ID?
Yes.
They may be able to do it with the ID.
Okay. Thank you, John.
All right. Thank you.
Thank you.
You're welcome.
Court calls the case People versus Cortez Triblet.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of
Morning. Your name?
Chad Triplett.
Current people are unable to proceed.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you. Does he want his bond back too?
Want your money back?
He didn't pay anything. Should have said yes. And then court calls the case People versus Joseph Williams.
Your Honor,
Ron Brown appearing on behalf of Mr. Williams.
Joseph Fitzgerald Williams.
Thank you.
current people are unable to proceed.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
All right, yes, sir.
Thank you, sir.
Court calls the case People versus Talia Williams.
According to your honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Williams.
Hi,
Your name?
Kylia Williams.
Current people are unable to proceed.
Move to dismiss, Your Honor.
Who's that with you? You,
My mom.
your mom? Okay, I knew it had to. She looked worried. All right. People being unable to proceed, this case is dismissed. That is without prejudice. All right, thank you. Court calls the case People versus Alberta Wilson, one case.
Ron Brown appearing on behalf of Alvaretta Wilson. Your Honor. I've called her and she lives in Detroit.
And she also has another warrant outstanding. Court calls case of Eladot Property Management versus Nicole Freeland
Very related.
and Aaron Gates. Freeland, Gates, they are not here. If you'd like to call, raise your right hand. Solemnly swear or affirm testimony you're about to give is the truth, whole truth, nothing but the truth, so help you God. Go ahead.
Non-payment of rent, the rent to retain possession is $1,156.83 for cost of $325 for new redemption, $1,481.83. Plaintiff requested a default judgment. ESTA, the writ to issue after 10 days if the total amount remains unpaid, as well as a money judgment and amount. Believe they were present.
They were present. Judgment to the plaintiff, that is by default for possession and money, redemption amount, and money judgment in the amount requested. Writ to issue in 10 days. Court calls the case of Evergreen Apartments versus Mia Garrison. Mia Garrison, No response, you may proceed.
Thank you, Your Honor. The rent to retain possession is $2,107.09 for a cost of $170. Redemption of $3,279.69. Plaintiff is requesting entry of a default judgment for possession only with a writ to issue after 10 days. The total amount remains unchanged.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested. The writ to issue in 10 days. Evergreen Apartment versus Dwayne Watson.
Marissa Gazari for plaintiff.
Good afternoon, Your Honor. I'm Dwayne Watson.
Good afternoon, sir. All right, where are we on his?
Your Honor, balance is $3,510. And that the Hawk application was denied.
That's what I'm looking for on this sheet. Watson. Okay, client is the last you have that it was denied.
Yes, the note that I have from my client says that there wasn't sufficient income for their requirement.
Okay, when did you get that message? So this is where.
It's from my client. It just came through as news. I don't know when it was.
Got it, because the sheet they sent us says client is sending last check stub 4/9 for eligibility determination. Did you already do that, sir?
Yes, sir.
When did you do that?
Okay. The last time I was in court, I talked with the Hawk organization, talked with Alicia Sykes. That what the attorney said is correct, but things didn't change as of today. I talked with Hawk.
When did you last talk with Hawk?
Today. I talked with Miss Alicia Sykes. I also talked with Miss Sydney. I can't think of her last name.
What did they tell you?
Well, I've paid over $1,000 this month. So my remainder balance is $2,996 and some change. I talked with Alicia Sykes today. She said that everything, what I did, if they approved of the grant to take care of the remainder balance.
What time was that conversation?
This was about, I want to say about 9-10 o'clock this morning.
And you get a message saying he was denied sometime today.
I can message Sykes. See.
Sure. All right. Why don't you have a seat?
Yes, sir. Thank you, Your Honor.
That's the problem with this paper thing that they have now, because things can change, and it was much better when we had Amy present. Well, I guess that's not up to me. Gulfside Lake 1 and 2 versus Lakia Williams
Here.
and Coran Williams. Lakia Williams, Coran Williams. Okay, have you received their check for 3,000?
So I have their balance as $1,660.
That be April?
Yeah, the $3,000 check came in on the 3rd of April, or maybe it was the 2nd of April. And it was applied to the ledger. So yes, my balance is
Is her April rent?
yeah, all of these.
Oh, boy. Okay, so here's part of the problem. Part of the problem is she's not here because she's always here. She's not here because she got her balance down to 3,000. They said they were going to pay it. She believes that she's clear. I'm sure of it.
My notes from the last hearing indicate that she was gonna pay April rent by the 3rd.
Oh, she was. That. Okay, I don't have that. Let's do this, because otherwise what's gonna happen if, I don't think I could properly dismiss it. Let's try to give her another shot to come in, because since we're just dealing with April, because we were much further behind. Let me adjourn it out to the 17th. At 1 p.m. Let's see, and if she doesn't show up or doesn't pay, then I'll deal with it then. Gulfside Lake 1 and 2 versus Dewan Wintermate.
Carissa, what was the last name? Sorry, what was the last name?
Wintermate. That you may not think. I said this for a writ hearing. Oh, I do. It looks like they paid. That's why you may not have anything. And your office sent in a satisfaction.
Yeah.
So, case is satisfied. Wow. Gulfside Lake 1 and 2 versus Deion Brown.
Sorry.
Here.
Hello, Your Honor. Deion Brown.
Yes, sir. How are you?
Doing well.
All right. Let's see. Where is he now?
$1,006. I had a note from my client indicating there was that Mr. Watson had indicated there was amount in escrow.
Yes. So I have 620 in escrow.
Plaintiff would request that would be released.
Yeah. And how much is your monthly rent?
$675.
Okay. So he paid this on that. Okay.
And then I made another payment on the 9th.
So you paid another payment on the 9th to the landlord?
I did it online. It was for something. I'm not exactly the exact amount, but I emailed.
Hold on a second. You paid some 400 on the 9th yesterday?
Yeah, I paid after the 620, whatever the remaining balance was. That's what was paid on the 9th.
Got it. I see what you're saying. So do you see that?
Yes, I see $445 paid, so it would leave the balance at 600.
665. Okay. So, and I have 620. So you're about 645, you said. So you're about $25 short.
So technically the late fee is being waived because I paid it before the 10th. I already talked to Melissa. She emailed me. I have the copy of the email. She said she would email the lawyer to let her know.
Okay. Here's what I'm going to do. Okay. You got that in. So what I'm going to do is release the 620 to the plaintiff. I'll adjourn this out 1 week. Okay. And let them, because I'm talking about $25. So let that get settled. If it doesn't go that way, just pay the 25 if you got it. Okay.
She told me that the funds had to be released from escrow first before she could remove the late fee.
All right. I'm releasing it today. I don't know when it'll get there. I'll adjourn it out to the 17th, 2026 at 1 p.m. Okay. So hopefully that check can get there. She waives that, then you're all set. Okay.
All right.
If you are, then yeah, I don't need to see you.
Okay.
Okay, but you might want to check before you don't show up.
If it's
Just check and make sure they receive the check.
okay, thank you.
Got it?
Got it.
All right, so have a good weekend.
All right, have a good weekend.
Strong Future Homes versus Ashley Womack.
There for plaintiff? Not sure.
Ashley Womack. Oh, there she is.
Hello, Your Honor.
Hello.
Ashley Bowman.
All right. She just had, well, what do you have as her balance?
I have $2,272.28.
Okay, so she's under the 3. You had her intake appointment with Hawk on the 7th.
Yes, they told me that all I had to do was bring in or send in the paperwork. The only reason I haven't done that yet is because I received the paper yesterday. Do I owe like a security deposit?
Pardon?
I received like the paper from the courts and it says I have a $300 security deposit too. So that's why I haven't turned that in.
300 free deposit?
Yeah. Which is really weird because I've lived there for like 6 years. I don't know why I have another security deposit.
Well, I'm saying.
It was like 300.
Pardon?
Ledger.
Yeah, and I don't see anything on the complaint.
Is there a way to get a paper from here that shows how much so I could send it into Alicia? Because that's the only issue is that the paper I have says I owe $353 security deposit.
I don't know where that paper is coming from, ma'am. Only, and the reason I say that is I'm looking at a copy of the complaint. And it doesn't say anything about a security deposit.
That's really weird. Because the first paper I got, it didn't have it had like 1 cent is what I owed on security deposit. And then the paper I got just yesterday says.
Is that coming from the landlord or is it coming from?
I think the landlord.
Okay. So I don't know anything about this.
Okay.
Okay, so what they want you to turn in is the complaint that you received.
Okay.
I think that's the paperwork that Hawk is looking for.
Yeah, they said from the courts of what I owed. So
Yes, so they're gonna want a copy of the complaint. You would have gotten one by mail. You would have gotten 2 by mail. And then 1 would have been delivered to you somehow.
okay, I got them all at once actually.
Yeah, okay.
So that's
what I'm gonna suggest you do is get that paperwork, get clear with Hawk what they want. But I think they want your complaint.
okay.
And they're gonna want a ledger or some type that either they'll get from the landlord or from you.
Okay.
So you might, what I'm gonna suggest you do is go down to your landlord, get a copy of your current ledger and your paperwork that from the court and get that to them.
Okay.
Okay.
That show issued a check. So that's all.
Right. I'm sure that's what they're looking for. They're just looking for that current balance. So let me adjourn this out to the 17th, 2026 at 1 p.m.
Thank you.
And let's see where we are, but make sure to get that paperwork down to them. Okay. All right. Thank you. Then I have Evergreen versus Figueroa. That's dismissed on plaintiff's. And do we? Watson, did more time on that?
Oh, I'm sorry. I'm just waiting. I just sent the email, so.
Got it. Okay.
Your Honor,
He looks comfortable saying word. Yeah, go ahead. Wait.
I'm sorry, I didn't mean to interrupt. Is there anything I can prevent to expedite this case right here?
Well, no, I'm waiting. What you said. Come on back up. Court calls the Watson. Go ahead. State your name again.
Dwayne Watson.
Okay, go ahead. What do we know?
It's like a zero for plaintiff. I just received an email from my client saying that there is an update from Hawk today. His application is now. So.
Okay, all right. Kind of what I have. Well, yeah, I get it. Don't worry about it. We got it solved. All right. So his application's approved. Which, if they cover everything, what do you have as his current balance?
I have $3,510.09.
Okay, so what he's gonna need to get in is 510.
I took care, I didn't mean to interrupt. Go ahead, sir.
No, go ahead.
I took care of that today. I can show proof.
You just doing all kinds of stuff. So you paid the 510.
Yes, sir.
Got it. Which is probably why they approved it, because
Yes, sir.
paid that. All right.
Absolutely.
So let me do this, Mr. Watson.
I have that now in new ledger as well, so
You have the 510. So he is at 3,000,
we got
a little under 3,000. They've approved him probably for the 3,000. Got it. Okay. So here's what I'm going to do. I'm going to adjourn it out 1 week. Let that check get through.
Yes, sir.
If they paid it, I don't need to see you.
Okay.
Okay. If they haven't, stop in, just try to make sure you're all clear.
Yes, sir.
Okay.
Yes, sir.
All right, Mr. Watson. You have a great weekend.
Hey, you as well. I appreciate you, sir.
All right.
Right on.
Thank you. All right. That's it for that, boss? All right. We're back on time again. Sure that will get all messed up because Mr. Hampton. All right.
I bit my tongue.
The judge called him a Tasmanian devil, and seconds later, his future changed forever. Everyone in the courtroom could see this defendant was exhausted. He had already spent days in jail, admitted violating his probation, and knew there was a real chance he was about to lose his freedom. When the judge asked if the allegations were true, he admitted he had failed to report, failed drug testing requirements, failed to pay his fines, and failed to complete the treatment program the court had ordered. At first, it sounded like just another probation violation. But then the defendant began explaining what had happened. He said he had been trying to get into a culinary training program that would provide housing and help him rebuild his life. The plan fell apart when required recommendation letters never came through. At the same time, he was trying to care for his wife, his disabled mother, and his 3 young children, while struggling with addiction and mental health issues. Then he did something many defendants never do. He stopped making excuses. He looked at the judge and admitted, "I'm the one who failed. I broke my promises. I made bad decisions." The courtroom fell silent. The judge listened carefully before responding. He agreed the defendant had finally started taking responsibility. But then he delivered a statement that nobody expected. He said he had once described the defendant as a Tasmanian devil. Not as an insult, but because he had become a spinning tornado of chaos, hurting the very people he claimed to love most, his wife,